Hello and welcome everybody to another video of Navigate AIF. In this video, I will discuss the recent SEBI circular introduced on 13 December 2024 on the subject of pro-rata and pari-passu rights of investors of AIFs. This circular was introduced after the amendment to the AIF regulations that were introduced on 18 November 2024 with respect to maintaining pro-rata and pari-passu rights of investors in a scheme of an AIF. So in this amendment, we saw that there were two new sub-regulations introduced. The first was Regulation 20, Sub-Regulation 21 of the AIF regulation, which states this: the investors of a scheme of an AIF shall have rights pro-rata to their commitment to the scheme in each investment of the scheme and in the distribution of proceeds of such investment, except as may be specified by the board from time to time. So except as may be specified by SEBI, provided that the rights of the investors of a scheme of an AIF issued prior to the notification of the AIF regulations, 5th Amendment regulations. So this date of notification is 18 November 2024. So the rights which are introduced prior to the date of this notification, which are not pro-rata to their commitment to the scheme and are not exempted by the board, shall be dealt with in the manner specified by the board. So in this circular, actually they will tell us how to deal with these investors if their rights are not pro-rata to the commitment of the scheme. Now, one important point that I wanted to mention here is that this sub-regulation that was introduced under the amendment to the AIF regulation is in stark contrast to actually what was proposed in the consultation paper. So I'll show you the consultation paper also. In the consultation paper on this issue, that is pro-rata and pari-passu rights of investors, what was proposed is that the rights of each investor shall be maintained pro-rata to their commitment to the scheme in each investment of the scheme while making investment, and pro-rata to the investment made in the investee company while distributing the proceeds of the investment, provided that the manager may charge performance linked fees as per the terms of the contribution agreement with each investor. Now what is being proposed is that the rights of each investor shall be maintained pro-rata to the commitment while making investment as well as while distributing. And this actually has a very significant impact in how you do your fund accounting. And I would like to show this with the help of an example. So here is an Excel sheet with which we can see the difference of making distributions pro-rata to the invested amount versus pro-rata to the commitment amount. So let us understand this with the help of a very simple example. We have two investors, A and B, in a particular fund. Both are committing the same amount of money, that is rupees 100, and contributing all of their commitment amount. The management fees of both is different. So investor A is at a higher management fee of 5% per annum and investor B is at a management fee of 0.25% per annum. They both are paying operating expenses. Setup expenses are only charged on investor A. Then you can see that the invested amount of both of these investors would be very different. How would you calculate this invested amount? The invested amount is equal to the contribution amount minus the fees and expenses that are charged to them. So I've put the formula here. You can see the contribution amount minus the fees and expenses. Now if you are making distributions, if you are making the pro-rata share when making investment as pro-rata to the commitment amount, then both will commit 50-50 and the share will be 50-50. Now while distributing, if you actually take this distribution on invested amount, then there will be the pro-rata share of distribution will be 48.71 and 51.29. How do I get this? So the invested amount is 94.25 of investor A and 99.25 of investor B, because we have reduced the fees and expenses. So the pro-rata share of invested amount would be very different. While if you look at the pro-rata share while distributing based on capital commitment, then again it is 50-50. So it is very important that on what basis are you calculating the pro-rata share while distributing? Is it on invested amount or capital commitment? The consultation paper said that this would be on invested amount, whereas what we are seeing in the regulations and in the circular is that the law is now saying that this pro-rata share should be on capital commitment. So this impacts investors who have lower fees. Because if I was an investor who was investing in a fund at a lower fee rate, while making the investment, I would have assumed that I would get this benefit as well at the time of making distributions, whereas that benefit is no longer applicable to me. So let us continue with the analysis of the circular. So in this regard, it is specified that the requirement of maintaining investor rights pro-rata to their commitment to the scheme shall not be applicable in an investment of a scheme and distribution of proceeds of the investment to the extent that an investor has been excused or excluded from participating in the said investment, or an investor has defaulted on providing his or her pro-rata contribution for the said investment. So only in these two circumstances can you say that the requirement of maintaining investor rights pro-rata to the commitment shall not be applicable. When do we have excuse and exclusion? There is a SEBI circular, in fact, on this issue on when you can excuse or exclude an investor. For example, if the investor gives you a legal opinion stating that their investment in the scheme, them being invested in the scheme would be in contravention to the law, or in case it's against their internal policy. In all such situations, you can excuse or exclude the investor. And default is when the investor has not made the capital contribution after a drawdown call. So these are the two scenarios that have been specified. Further, the requirement of maintaining pro-rata rights of investors in distribution of proceeds of investment of a scheme shall not be applicable to the extent returns or profit of the investments is shared by an investor with the manager or sponsor of the AIF in terms of the contribution agreement executed between them. So this would refer to the carried interest or the additional return as it is specified in many PPMs. So you cannot have the requirement of maintaining pro-rata rights in distribution with respect to the additional return carry component, because of course that cannot be pro-rata, and that is in the ratio that has been specified in the PPM as per the agreed commercials of the fund. Next, additionally, to provide flexibility in fundraising from investors with varied risk appetite, the following entities may accept returns lesser or share losses more than the pro-rata rights in investments of an AIF or scheme of an AIF. That is, they may subscribe to classes of units which are junior or subordinate to other classes of units of the scheme of an AIF. Now, this is essentially the priority distribution model which was banned by SEBI, as we had seen in the SEBI board meeting and as will be specified in this circular as well. But SEBI has now provided that for these type of investors, they can enter into something like the priority distribution model, where they may agree to accept returns which are lesser, or they may agree to share losses more than the pro-rata rights. So they can subscribe to junior or subordinate units. Now, who are these people? This can be the manager or sponsor of the AIF. It can be multilateral or bilateral development financial institutions, DFIs. It can be state industrial development corporations, and it can be entities which are established or owned or controlled by the central government or a state government or the government of a foreign country, including central banks and sovereign wealth funds. For these people, priority distribution model has been permitted to this extent. Next, in case manager or sponsor of an AIF subscribes to junior or subordinate classes of units of an AIF, it shall be ensured that the amount invested by the AIF scheme is not utilized by an investee company directly or indirectly to repay any of its obligations or liabilities towards the manager or sponsor of the AIF or their associates. So this is essentially to ensure that there is no evergreening, that they cannot repay their obligations. So you cannot repay loans that they have taken from the manager or sponsor of the AIF or the associates. There's something you have to ensure compliance with. One important point that I want to mention here is that Regulation 20, subclause 21 is also applicable in case of angel funds. And this was also introduced in the AIF regulations with an amendment to Regulation 19B, wherein subregulation 21 of Regulation 20 was also introduced in this clause. Therefore, this regulation, that is with respect to maintaining rights pro-rata to the commitment of the scheme, this is also applicable to angel fund. So make sure that you make a note of this point as well. Next, we see the applicability on existing schemes of AIFs or existing AIFs. The SEBI circular dated 23 November 2022 says that schemes of AIFs that have adopted the priority distribution model were directed to neither accept any fresh commitment nor make investment in any new investee company until a view is taken by SEBI in this regard. Further, in terms of the proviso to Regulation 20, Subregulation 21 of the AIF regulations, as referred to above. So where we read this above as well. This is again mentioned here. What does the proviso state? It states that the rights of investors of AIFs or schemes of AIFs which are issued prior to the date of notification, that is 18 November, that are not pro-rata to their commitment to the AIF scheme and not exempted also. So we saw the ones who are exempted, and if these rights are not pro-rata to their commitment, they shall be dealt with in the manner as specified by SEBI. So what does SEBI specify now? SEBI is saying that it is hereby specified that existing AIFs or schemes of AIFs that have adopted the priority distribution model and are not falling under the exemption at paragraph 5 above shall neither accept any fresh commitment nor make any investment in any new investee company directly or indirectly. So essentially you cannot fundraise anymore, nor can you invest the funds that you have already raised. Now we saw the one that are falling under the exemption at paragraph 5, that are these 4 type of investors. So if you are an existing scheme with a priority distribution model, this is what is the law for you now, and SEBI has taken a view in this regard. So if you are part of an AIF or a scheme of an AIF that will be breaching its investment limits by virtue of compliance with this regulation, that is, you may have adopted a priority distribution model and are not falling within the exemption at paragraph 5, and since you cannot raise any more funds or make any investments, if you are breaching your investment limits, this breach will not be considered as non-compliance by SEBI, but make sure that you record this in your compliance test report, which will be filed annually. An interesting question is, what is the timeline to file the compliance test report annually? This is a common question in the NISM exam, and that is 30 days from the end of the financial year. Next, we see what has SEBI specified with respect to pari-passu rights of investors of AIFs. So Regulation 20, Sub-Regulation 22 of the AIF regulations states as under: the rights of investors of a scheme of an AIF other than that specified in Sub-Regulation 21 of this regulation shall be pari-passu in all aspects. So all your rights of investors in scheme have to be pari-passu in all aspects. So what does it mean to say that the rights are pari-passu? It means that investors will be held on an equal footing in all aspects. You have to treat all investors equally, provided that differential rights may be offered to select investors of a scheme of an AIF in the manner as may be specified by the board without affecting the rights of other investors of the scheme, provided further that this requirement under Sub-Regulation 22 of this regulations shall not apply to LVFs, large value funds for accredited investors, provided further that any differential right already issued by an AIF prior to this to the notification of the SEBI AIF regulations, 5th Amendment regulation, that was on 18 November, not falling within the first proviso to Sub-Regulation 22 shall be dealt with in the manner specified by the board. Now, not falling within the first proviso means if there are any differential rights that are already issued, and these differential rights may only be offered to select investors of the scheme. So if they are not offered to select investors in the manner specified by SEBI without affecting the rights of other investors, this will also be dealt with in the manner as specified by SEBI in this circular. Accordingly, in terms of the first proviso to Regulation 20, Sub-Regulation 22 of the AIF regulations, it is specified that differential rights may be offered by AIFs to select investors without affecting the rights of other investors based on the following guiding principles. So, what typically are these differential rights which may be offered to select investors? These are of course the rights that you have under your side letters. What is a side letter? A side letter is a separate letter agreement that is entered into between the investor and the investment manager or the fund. The fund is of course a party to it. So it's entered into in addition to the contribution agreement that is signed by the investor. In the side letter, there may be certain commercial or non-commercial terms that the investor may seek from the fund. Typically, what the investor would ask for would be lower fees, or the investor may ask for additional reporting requirements, etc. And this is generally asked for by investors who have a larger ticket size in the fund. So if they are making a significant investment in the fund, they would request for a side letter to get better rights from the fund. Now, accordingly, in terms of the first proviso to Regulation 20, Sub-Regulation 22, it is specified that differential rights may be offered by AIFs to select investors without affecting the rights of other investors based on the following guiding principles. Any such right shall not result in any investor bearing liability accrued or accruing to other investors of the scheme of the AIF. So your right cannot result in others bearing liability. So it cannot result in one investor bearing the liability accrued to other investors of the scheme. You cannot change the liability that has accrued to investors in the scheme. Any such right with respect to non-monetary or non-commercial terms shall not provide control to an investor on the decision making of the AIF scheme, except in cases where investor or its nominee is part of any committee set up in terms of Regulation 20, Sub-Regulation 7 of the AIF regulation. This is of course the investment committee. So the investor can be part of the investment committee, but these rights cannot provide control to the investor on decision making of the AIF scheme apart from the framework of the investment committee. So here SEBI is making sure that the core function of the fund, that is making investment decisions and divestment decisions, should always rest with the investment manager, and you cannot give this control to the investor except through an investment committee. Now, why is SEBI permitting this through an investment committee? Because the code of conduct is also applicable on the investment committee. So if you're a member of the investment committee, you will automatically follow the code of conduct, and in that scenario, in that limited way, you can actually make investment decisions in the AIF scheme as an investor. Next, it says that any such right shall not alter the rights available to other investors under their respective agreements with the AIF or manager. You cannot have rights which alter rights of other investors, and any such right and eligibility to avail the same shall be transparently disclosed in the PPM of the AIF or scheme of an AIF. So you have to also disclose these rights and eligibility in the PPM transparently. This is typically done in the side letters clause. In this regard, it has been decided that the standard setting forum of AIFs shall, in consultation with SEBI, formulate the implementation standards for compliance with the aforesaid provision, prescribing the positive list of specific differential rights that may be offered by AIFs. Such list may be reviewed and updated by the SFA, the standard setting forum, whenever necessary in consultation with SEBI. So recently SEBI has been using the standard setting forum to come out with implementation standards, and this was also observed in case of the specific due diligence requirement, wherein the standard setting forum actually released the implementation standards, as well as in case of the PPM audit requirement, wherein the new format of the PPM audit was actually released by the standard setting forum. So recently we can see SEBI is working very closely with the standard setting forum, and it's a good idea to keep an eye out on these SFA associations. So this is typically the Indian Venture and Alternate Capital Association, that is the IVCA, and the PEVC CFO Association, and the Trustee Association of India. On their websites, you will see the implementation standards which will be formulated. I will also make sure that I put this out on my social media whenever they release the implementation standards, and the timeline for this is on or before January 15, 2025. AIFs, managers of AIFs, and their key management personnel shall ensure the following while issuing differential rights to select investors. First, they will ensure that the differential rights shall be provided only in accordance with the implementation standards formulated by the SFA. The following shall be disclosed in the PPM. First, eligibility criteria of an investor to avail each differential right, and second, any investor meeting the specified eligibility criteria for a differential right may opt to avail such right. Now, very importantly here, this requirement is also on key management personnel. So now these key management personnel have to make sure that their PPM is in line with the circular, and they have to mention that this is disclosed in the PPM, as well as implementation standards, that the differential rights are in accordance with the implementation standards. So recently, more and more circulars, we are seeing SEBI actually impute responsibility on the key management personnel and make sure that if when you're updating your PPM this year, you make these changes in the PPM. What about the applicability on existing schemes of AIFs or existing AIFs? In terms of the standard template of SEBI prescribed, template for PPMs prescribed by SEBI, via its circular dated 5th February 2020, AIFs are required to disclose to investors in their PPM that any differential right offered to an investor through separate classes of units or side letter or side agreements shall not have any adverse impact on the economic rights of any other or any other rights of other investors. In terms of the standard template for PPMs prescribed by SEBI, this is the standard template for Cat 1, Cat 2 as well as Cat 3 AIFs. Here, actually, in this standard template, you are required to disclose that any rights which are offered, any differential rights which are offered to investors through separate classes of units or through side letters or agreements shall not have any adverse impact on the economic rights or other rights of other investors. This is a requirement even now, and I'm sure in all the PPMs that have been made after the standard template, this right would have been mentioned in the side letter clause. AIFs or schemes of AIFs whose PPMs are filed by SEBI post applicability of this circular, that is, the applicability of the circular was from 1st March 2020. So any PPMs which are filed with SEBI post the applicability of the circular shall comply with the following. The manager shall report the details of differential rights which do not fall under the implementation standards formulated by SFA to SEBI in the format given at Annexure 1. So I'll read Annexure 1 also later, where SEBI has prescribed the format in which you will have to report differential rights that have been provided which do not fall under the implementation standards, and this has to be submitted by emailing to SEBI on or before February 28, 2025. So make sure that this date is also added to your compliance calendar as an additional compliance on this date. Next, out of the rights reported to SEBI as per paragraph 17.1 above, that is the differential rights which do not fall under the implementation standards, the manager shall immediately terminate or discontinue those differential rights which are ascertained to be affecting the rights of other investors. Now, this is a very significant provision because essentially what it is stating is that your side letter agreements which have already been entered into with investors, and it's also important to understand that a lot of investors here would be foreign investors who would have negotiated these rights. If these rights do not fall under the implementation standards formulated by SFA, you have to discontinue these differential rights, essentially cancelling these agreements. I can imagine that this may have a very significant impact on fundraising by investors abroad or fundraising in India as well with large family offices or large institutions, because these are the ones typically who request these differential rights. And it's very important to see what actually is released by the SFA, because basis this we will know what side letters have to be terminated, and I can only imagine the impact of this, which I expect would be very significant. And this is something you should make sure that you keep an eye out for, and make sure that the details of the differential rights are also submitted to SEBI within this timeline. Now, what has been specified with respect to LVFs? So LVFs whose PPMs were filed by SEBI for launch of scheme post the date of issuance of this circular may avail exemption from the requirement of maintaining pari-passu rights. So this circular here is essentially this December 23 circular, not the February 5 circular. So any LVF schemes which are launched now may avail the exemption from the requirement of maintaining pari-passu rights, subject to the following. If they make appropriate disclosure in the PPM of the scheme that they will not be following pari-passu, not be maintaining pari-passu rights among investors. Next is obtaining an undertaking from accredited investors at the time of onboarding to LVF in terms of paragraph 4.1 of Annexure 8 of the Master Circular, with the following clause inserted for waiver. What is the clause that has to be inserted? The prospective investor is aware that LVFs may avail exemption from the requirement of maintaining pari-passu rights among investors, and therefore may offer differential rights to select investors that might affect the interests of other investors of the LVFs. Now, what is this undertaking actually in paragraph 4.1 of Annexure 8? So this undertaking is actually an undertaking that prospective investors shall, inter alia, submit a copy of the accreditation certificate and an undertaking to the investment service provider, that is essentially the fund manager, to the effect that the prospective investor consents to avail benefits under the accredited investor framework. The prospective investor has necessary knowledge and means to understand the features of the investment product or service eligibility for accredited investors, including the risk associated with the investment. The prospective investor is aware that investments by accredited investors may not be subject to the same regulatory oversight as applicable to investment by other investors. And last, that the prospective investor has the ability to bear the financial risks associated with the investments. So anytime that an accredited investor is actually joining an LVF, they make these, they have to give an undertaking as we just read. Additionally, this clause has to be inserted for waiver from the requirement of maintaining pari-passu rights in the same undertaking if the LVF makes the appropriate disclosure in the PPM. Existing LVFs may avail exemption from the requirement of maintaining pari-passu rights among investors, subject to each investor of the scheme specifically providing a waiver to this effect as mentioned above. So every investor has to provide this waiver. Only then can LVFs also avail the exemption of maintaining pari-passu rights. With this circular, you have to ensure compliance. The trustee and sponsor has to ensure compliance in the compliance test report, and this circular has been brought into force immediately. Now, just very quickly, I would like to go through Annexure 1, which has to be submitted by 28th February 2025. In this, you have to report differential rights issued to investors. So you would have to say the name, registration number, name of the scheme, manager, list of differential rights and the terms under which such differential rights have been issued by the AIF or scheme. This information has to be submitted. Additionally, the details of differential rights issued to select investors which are not covered in the implementation standards formulated by the standard setting forum have to also be provided here. These details have to also be provided here. You have to say differential rights which are not covered in implementation standards, whether the differential right disclosed in the PPM was disclosed in the PPM. So here you would mention yes or no basis what has been disclosed in the side letters clause, whether the differential rights affects the rights of other investors of the AIF or scheme, and any remarks. And this information has to be sent in an Excel format on this email ID to SEBI by February 28. So thank you for listening. If you have any questions on this circular, feel free to reach out to me, and I would be happy to discuss your thoughts as well on this circular. Thank you.